and welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host, Ostika Das, and I'll take you through the most significant courtroom developments from this week. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website, www.livelaw.in. In today's episode, we are going to talk about the Women's Reservation Bill, the latest development relating to Udhayanidhi Stalin's remarks about Sanatan Dharm, the Muzaffarnagar child slapping incident, Chandrababu Naidu's appeal against the Andhra Pradesh High Court refusing to quash criminal proceedings against him, and much more. So let's dive into the headlines. We begin with a significant constitutional development. Last week, we told you that the Parliament has passed the Women's Reservation Bill with broad bipartisan support. This Friday, the central government notified the Constitution 106th Amendment Act 2023 in the official gazette after the President of India gave her assent to the bill. So what does this act propose and when will it come into effect? The Constitution 106th Amendment Act seeks to reserve 1/3 of seats for women in the Lok Sabha, state legislatures and the Delhi Legislative Assembly. Accordingly, Article 239AA of the Constitution has been amended and new Articles 330A and 332A have been introduced. It must also be noted that 1/3 of the total number of seats reserved for women will be further reserved for women from scheduled castes and scheduled tribes in an effort to provide horizontal reservation for these disadvantaged sections. Another new article has been introduced, that is Article 334A, which contains a sunset clause saying that this policy of affirmative action will come to an end after 15 years from the date of the Act's commencement. Another thing that you must note is that while this is no small victory for the legislators across party lines who have been advocating for women's reservation for decades, this Act will only come into effect after a delimitation exercise following the first census conducted after the Act's enactment. This is owing to the operation of Article 334A, which other than stipulating the time when the reservation will come to an end, also lays down when it will be enforced. During the parliamentary debates, members of the ruling Bharatiya Janata Party has also clarified that the Act will not be implemented before the upcoming general elections in 2024 and it might not get enforced at all before 2026. While on the topic of women's reservation, there is an important update relating to the state of Nagaland. The Nagaland government has informed the Supreme Court about a recent bill introduced in its Legislative Assembly proposing a 33% reservation of seats for women in urban local bodies as per Article 243 of the Constitution. The bench headed by Justices Sanjay Kishan Kaul was hearing a contempt plea filed by the People's Union for Civil Liberties accusing the state of Nagaland of not complying with the court's earlier order directing the state government and the State Election Commission to conduct local body elections with 33% women's quota. Nagaland's Advocate General K.N. Balgopal has informed the court this week about the new bill introduced in September, which was the outcome of widespread support for women's reservation among tribal organizations. He also informed the court that the bill is now with a select committee before asking for the hearing to be deferred until November 10th, assuring that the final order would be passed by Justice Kaul, who is set to retire in December this year. Next, let's turn to a development relating to Tamil Nadu Minister and CM M.K. Stalin's son, Udhayanidhi Stalin's recent comments on Sanatan Dharm, which triggered a massive political row. He allegedly suggested eradicating Sanatan Dharm instead of opposing it, comparing it to combating diseases like dengue and malaria. Several pleas have been filed in the Supreme Court, all seeking action against the DMK leader. Last week, a bench headed by Justice Aniruddha Bose agreed to issue notice in one of the pleas filed by a Chennai-based lawyer seeking the registration of an FIR against Udhayanidhi. This week, a similar plea was taken up by the bench. Although the court refused to issue notice in this one, it directed this petition to be tagged with the last one to be heard together. During the brief courtroom exchange, Tamil Nadu Additional Advocate General Amit Anand Tiwari raised concerns about the volume of litigation filed over Udhayanidhi's recent remarks in as many as 40 courts across the country. These were not public interest litigation but publicity interest litigation, the law officer contended, asking the court why another petition with almost identical prayers was being entertained when notice had already been issued in one. In response to this, Justice Bose said that the question of entertaining the petitions would be examined on the next date of hearing. Next, We have news relating to the Muzaffarnagar slapping incident, which was brought to the attention of the Supreme Court in a PIL filed by Tushar Gandhi, a social activist and the great-grandson of Mahatma Gandhi. Now, if you don't know what this is about, here's a little context. A video from a school in Muzaffarnagar, Uttar Pradesh, depicting a teacher instructing students to slap a Muslim classmate recently went viral, causing much public outrage. Not only did this result in an FIR against the teacher for causing harm and provoking a breach of peace, but also led to Gandhi filing a PIL in the apex court, seeking a thorough investigation. On the last occasion, while issuing notice, the court had directed the Muzaffarnagar Superintendent of Police to submit a report on the investigation's progress. This week, the bench headed by Justice Abhay S. Oak expressed dissatisfaction with the Uttar Pradesh Police's handling of the case, particularly over the delay in filing the FIR and the omission of allegations of communal hatred from it. Consequently, the court ordered that a senior IPS-ranked police officer investigate the case. The state government has further been asked to provide expert counselling to the victim as well as other children involved in this incident and to provide facilities to the victim in terms of the Right to Education Act and Article 21A of the Constitution. Compliance reports have been sought before the next date of hearing on 30th October. Notably, the court also observed a prima facie failure on the part of the state to adhere to the Right to Education Act and rules, which prohibit the physical and mental harassment of students and their discrimination based on their religion and caste. The bench noted that if the allegations were true, it should shock the conscience of the state. It said, and I quote, "There cannot be any quality education if a student is sought to be penalized only on the ground that he belongs to a particular community." This year, Delhi University introduced a 5-year integrated law course, marking a departure from its long history of having only a 3-year LLB program. However, this led to a legal challenge with a student objecting to the Faculty of Law's decision to admit candidates only on the basis of CLAT scores. The petitioner who approached the Delhi High Court argued that candidates should be admitted based on the Common University Entrance Test conducted by the Delhi University for other courses rather than CLAT, which is organized by the Consortium of National Law Universities. But the High Court granted the law faculty interim relief and allowed it to proceed with admissions on the basis of CLAT scores since classes had already started. Now the Supreme Court has refused to interfere with the interim order issued by the Delhi High Court, applicable only for this academic year. It must be noted that the broader question of whether the Common University Entrance Test scores should be made mandatory for admissions across all central universities, or if these institutions should have the flexibility to admit students through examinations conducted by other specialized agencies, is still pending and will be considered at length by the High Court. The Supreme Court, as you know, has been carefully monitoring the precarious situation in Manipur, which has been witnessing violent ethnic clashes since May. This week, the court issued additional directions to ensure the welfare of affected individuals and restore stability in the region. At the outset of this week's hearing, the Chief Justice's bench was informed by the Judges Committee that 12 reports had been submitted. This all-women Judges Committee, headed by former Chief Justice of Jammu and Kashmir High Court, Geeta Mittal, urged the court to pass necessary directions. Accordingly, the court directed the restoration of Aadhaar cards and bank details of displaced persons, provided their records were available with the Unique Identification Authority of India and subject to biometric verification where required. The court also directed that additional paralegals be appointed to address the shortage of secretaries at district legal services authorities. The union was also asked to nominate one nodal officer in Delhi for facilitating petitions and complaints from displaced persons and directing their grievances through the appropriate channels. Apart from this, the court granted 1 week for the state of Manipur and the Union of India to respond to the 9th report filed by the committee after senior advocates Josefa Ahmadi and Colin Gonsalves raised concerns about the destruction of churches and religious buildings in Manipur. Additionally, Chief Justice Chandrababu also said that it would review a sealed cover report filed by the Manipur government regarding seized weapons stolen from the state armory. Moving on to the second development relating to the Manipur ethnic clashes. Earlier this month, reports emerged that the home of Professor Kham Khan Suwan Housing's lawyer had been vandalized by a mob. For context, Housing is a kooky professor who has spoken out against the alleged role of the state and Meitei outfits in the ongoing clashes. Some of his statements have even led to a police complaint being registered against him, accusing him of defaming the Meitei community and provoking communal enmity in the state. Even though the Supreme Court granted the political scientist protection against coercive action while he approached the Manipur High Court, the Hyderabad University professor was left with no legal representation after the attack on his lawyer's home and office, which was followed by his lawyers withdrawing from the case. On a previous occasion, senior advocate Anand Grover flagged this issue of individuals from a certain community facing legal issues owing to the reluctance of local lawyers to represent them in the face of threats and intimidation. This week, Grover reiterated to the court that lawyers representing a particular community were facing threats, attacks, and barriers to appearing before the Manipur High Court, urging the Supreme Court to direct that these lawyers be provided with protection. In response, the Supreme Court bench headed by Chief Justice D.Y. Chandrachud directed the bar associations in the state to not obstruct any lawyer from appearing in court, regardless of the community to which they or their client belonged. Not only this, the court sternly warned the bar associations that disregarding its directive would amount to contempt of court. We have more news about Manipur. The Supreme Court has expressed renewed concerns about the central government's delay in deciding on various collegium recommendations for the appointment and transfer of judges to constitutional courts. This delay has been stressed with special reference to the Manipur High Court, which currently faces a vacant Chief Justice position, with the government yet to act on the collegium's recommendation to promote Delhi High Court Judge Siddharth Mridul. This recommendation to appoint Justice Mridul as the Chief Justice of Manipur High Court has been pending since July of this year. Other than this, the Justice Sanjay Kishan Kaul-led bench also pointed out that as of November 11th, 2022, 70 recommendations made by High Court collegiums remain pending with the centre. These had not yet made their way to the Supreme Court's collegium. Justice Kaul also stressed that 7 names that were reiterated by the Supreme Court collegium, 9 names that were proposed for the first time, and 26 transfer proposals were still pending, alongside the recommendation to promote Justice Mridul as the head of the Manipur High Court. And the court, saying this, urged Attorney General R. Venkataramani to seek instructions. Last week, the Andhra Pradesh High Court dismissed a plea by former Chief Minister N. Chandrababu Naidu for quashing of criminal proceedings against him in connection with a multi-crore skill development scam. Naidu was arrested in connection with this case on September 9th by the state's Crime Investigation Department. The Telugu Desam party leader subsequently challenged the High Court's order refusing him relief in the Supreme Court, and it was taken up this Wednesday by a bench of Justices Sanjeev Khanna and S.V.N. Bhatti. Right at the outset of the hearing this week, Justice Khanna informed the parties of Justice Bhatti's wish to recuse himself from hearing Chandrababu Naidu's petition. After Justice Bhatti's recusal, the matter was mentioned before the Chief Justice's bench for urgent hearing, and it was directed to be rescheduled to October 3rd. At the same time, Chief Justice Chandrachud also declined Naidu's request to restrain the trial judge from dealing with the state's application to interrogate him in police custody. Naidu is currently in judicial custody, and the last time the state CID was granted 2 days of custody on September 23rd and 24th. Last week, a 5-judge bench of the Supreme Court referred the 1998 P.V. Narasimha Rao judgment to a larger bench of 7 judges. In this judgment, the court held that legislators were immune from prosecution in bribery cases related to parliamentary votes and speeches under Article 105 Subclause 2 and Article 194 Subclause 2 of the Indian Constitution. However, the court specified that immunity applied only if legislators carried out the act that they received a bribe for. In other words, if a legislator took a bribe to vote for a candidate but later voted differently, the legislator would be disentitled from claiming immunity. This week, details regarding the composition of the 7-judge bench was released. The Constitution bench will comprise Chief Justice D.Y. Chandrachud and Justices A.S. Bopanna, M.M. Sundaresh, P.S. Narasimha and J.B. Pardiwala. The Supreme Court has referred a crucial question to a 7-judge bench regarding the enforceability of unstamped or insufficiently stamped arbitration agreements. This decision came during a curative petition challenging a 2020 ruling that rendered arbitration clauses in insufficiently stamped agreements unenforceable. While hearing this curative petition, the validity of the recent NN Global judgment was also called into question. In this case, a different bench headed by former Supreme Court Judge K.M. Joseph had ruled by a 3/2 majority that unstamped instruments could not be considered legally enforceable contracts under Section 2H of the Contract Act. Recognizing the significant implications and considerable uncertainty caused by this issue in arbitration law, the bench deemed it necessary to refer the matter to a larger 7-judge bench, which will begin hearing the reference from October 11th. The Supreme Court is set to examine the applicability of Section 67A of the Information Technology Act 2000 in cases involving profane language. This question has arisen in an appeal by the creators of TVF web series College Romance against the Delhi High Court's order upholding the registration of an FIR against them under Sections 67 and 67A of the IT Act. In March, the Delhi High Court upheld the registration of an FIR against the makers of the web series after concluding that language used was vulgar and not in line with the moral and community standards of a common man. Against this reasoning, senior advocate Mukul Rohatgi, representing the makers, argued before the Supreme Court that Section 67A does not apply to profane language as it pertains to material containing sexually explicit acts or conduct. He emphasized that the series portrayed how young adults speak in college, including the use of slang, which is a part of daily life. However, the bench comprising Justice A.S. Bopanna and Justice M.M. Sundaresh expressed reservations about this interpretation. Justice Sundaresh noted that Act in Section 67A has a broader meaning and should not be narrowly interpreted as referring only to physical acts. The matter is scheduled for further hearing on October 31st. Next, let's turn to some news from other courts. The Delhi High Court has ruled that religious scriptures cannot be copyrighted, but adaptations of such works, including TV series and dramatic works, are eligible for copyright protection. This decision came in response to a suit filed by a book trust against various websites, mobile apps, and social media accounts disseminating Bhagavad Gita and other copyrighted religious works. The court clarified that scriptures like the Bhagavad Gita are in the public domain and copyright cannot be claimed in them. However, adaptations, interpretations, and original works based on these scriptures are eligible for copyright protection. A Bangalore civil court has issued an ex parte interim injunction against X, which was formerly known as Twitter, ordering the suspension of the account of Dr. Cyriac Abby Phillips, known as the liver doctor, on the social media platform. The injunction was granted in response to a lawsuit filed by the Himalaya Wellness Corporation alleging that Dr. Phillips had made defamatory statements about the company's products. The company has claimed that Dr. Phillips's derogatory statements had resulted in significant business losses for the company, arguing that his statements were false and unjustified with the intention of promoting products from other companies. In response, the civil court not only directed X to suspend Dr. Phillips's account, but also restrained him from posting or publishing any further defamatory remarks about Himalaya Wellness Corporation or its products. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audiovisual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel, drop your thoughts and feedback in the comments below, tap that bell icon to get your notifications, and lastly, swing by our website www.livelaw.in for our in-depth reports. I'm your host Ostika Das and I will see you again next time.